All right. Hello, everybody. Welcome back to the Craig Henry and the Henry channels, respectively. Today is my first live stream. It's a second live stream since I've been out of jail. It's my first live stream, I think, like 49 or 50 days. So I don't even know if this notification will be going out to people. But I wanted to do this live stream. I haven't really talked a whole lot. I thought it would be a little bit easier to reintegrate into what I used to do as far as my role on YouTube and as far as everything else in life. But I found it a lot more difficult to do that than I originally thought I would find it. I see a couple people getting in here now. Hello, everybody. So yeah, with that being the case, I haven't been uploading as much. I haven't been talking as much. I haven't been speaking publicly. But today, we actually I'm able to live stream. I'm able to talk to you guys. So I figured I'd get back into it. And I wanted to talk a little bit. Obviously, as the title says, I want to talk about my appeal and what is going on with that. I told everybody what was going on. If you've been paying attention to my video, or if you paid attention to my live stream and my updates from in jail. But as of right now, I haven't really given anybody a in-depth look at what's going on in my appeal. And today I don't mean to give an in-depth hour-long, 2-hour-long look at it. I just mean to kind of give everybody the gist of what's going on in it, what the arguments are, what the state's argument is, what our response is, and then what the process is to getting this done. I do want to touch briefly. I'm sure there were a lot of people that were thinking maybe I wasn't appealing, or that maybe the appeal had failed because I did the whole 9 months. Of course, a lot of people that watch videos like mine are familiar with Chili DeCastro going to jail, and he went to jail on a conviction of disorderly conduct. He served, I think, 4 months, and he got out on appeal. His sentence was 6 months, so it was relatively quick. When you look at my case, I served the whole 9 months. The appeal didn't even start until February because of all the red tape that you have to cut through in order to do an appeal in Indiana. But my appellate attorney Kay Beeler is representing me in this appeal, and so I'm just going to kind of start out. So what I have here is the appeal paperwork that I received when I was in jail. Actually, the whole reason I have it is I was going through all of my stuff from jail, and I just had a huge pile of paper on my desk because I didn't really want to get rid of a whole lot of stuff when I was in there. I wanted to keep everything so that I had everything documented. But I went through, I got everything that I needed sorted out and thrown out. But so this is the introduction to our appellant brief. So the way that it works is you, as the appellant, you brief the court on your argument, and then the state comes back and responds. And after that, you come back with a rebuttal brief. So I'm going to read the introduction. I'm going to read the statement of the issue. I'm going to read the statement of the case, and I'm going to gloss over the facts relevant to the issue presented, because, guys, this is a thick amount of paper, and I could read through it all, but I don't think you all want to sit through that. So we'll just kind of get to the gist of it. So this is the introduction. It says, this case presents issues which are at the heart of a citizen's right to freely speak, to inquire of his government, and to criticize that government. The action of the state in criminalizing Appellant Henry's conduct as an independent journalist is comparable to prosecution of a news reporter who publicly exposes questionable government activity, comments with his or her opinions on the information, and is prosecuted when that information results in various citizens who react by sending letters to the editor, calling into radio stations, or otherwise reacting on social media to events they find troubling. This prosecution violates the due process rights of Appellant Henry, as well as his right under the First Amendment and Article 1, Section 9 of the Indiana Constitution. So that concludes the introduction to the case, to the appellant brief. I do want to point out that my attorney said that the case is very much like a journalist or a news reporter who publicly exposes questionable government activity, comments with his or her opinion on the information, and is prosecuted when that information results in various citizens who react by sending letters to the editor, calling into radio stations, or otherwise reacting on social media. I thought it was more akin to maybe a Fox News or someone of the like breaking a story on maybe a new act that they're trying to pass in Congress, and perhaps encouraging people to contact their senator or contact their House of Representatives representative uh, when if they don't like the bill, right? If they don't like the proposed law. And I think that what I did was more akin to that, because I never encouraged I didn't even encourage anybody to call. I always put the number out to the places that I would visit just in case anybody wanted to redress their grievances. But so we're going to move on to the statement of the issue. This is further into the appellant brief. My attorney says the state alleged that appellant Craig Hendry stalked Patricia Karanovich, who works in the City Hall of Clinton, Vermilion County, Indiana, based on numerous telephone calls into City Hall by unknown individuals following one of Hendry's YouTube posts. The state charged Hendry with aiding, inducing, or causing harassment, which the state argued constituted stalking under Indiana code. And it has a code. So what she's saying here is that the state's argument is that other people calling the City Hall of Clinton after watching one of my YouTube videos constituted one, aiding, inducing, or causing harassment, and two, the state argued that that constituted stalking under Indiana code. So that's the statement of the issue. So then she goes, do Hendry's few brief contacts with Karanovich during constitutionally protected news gathering efforts constitute sufficient evidence to support his stalking conviction, his stalking and harassment conviction? So this is the statement of the case. This is the third section of this brief. My attorney says, on November 21st, 2024, appellant Craig Hendry was found guilty of 1 count of stalking and 2 counts of aiding, inducing, or causing harassment. On December 17th, 2024, Craig was sentenced only on counts 1 and 4 to run concurrently. Post-verdict, the court vacated the verdict for count 5 to avoid double jeopardy. The clerk's record was filed on January 16th, and the transcript was completed and filed on February 20th. 1 extension was granted on March 17th when this court ordered the clerk to prepare and file an exhibit volume detailing the audio and video exhibits. 1 extension was granted on April 17th, and this brief of appellant is timely filed on or before May 20th. Of course, at that time, there was 41 days left in my sentence, so I'm glad that it was timely filed. We'll just leave it at that. So, and then she's got a lot of pages that talk about facts relevant to the issue of the case. But I'm going to jump ahead to her conclusion, and I'm going to go ahead and say it to everybody. I am going to make sure that everybody gets to have a little bit more of an in-depth look at this case, but I don't think that this is the platform that I want to do it on right now. I want it to be a very consumable piece of content. So, but that probably won't happen for a while. We'll see. So her conclusion is, and this is a little bit of reading, so I'm going to read it to you, and then we're going to move on to the state's response, which is always juicy, right? Them trying to criminalize constitutionally protected activity, or even just activity that falls under the inalienable rights that we have, right? But so this is the last paragraph of her statement of the issue. She goes, Craig's postings were not threats. A citizen has the unfettered right to, quote, political speech, unquote. That is, to express disagreement with or thoughts and opinions about government officials and actions taken by them. In conformity with federal cases, Indiana courts have steadfastly affirmed the right of a citizen to criticize government officials or actions, absent abuse by the speaker. Can anybody tell me why the courts, at least still to this day, can anybody tell me in the comment section, why do the courts say the courts have affirmed the right of a citizen to criticize government officials? Why do you think they affirm it as opposed to granting it, right? Somebody could tell me that in the comments. But I'm going to read on. So this is a quote from Brewington versus State. This is an Indiana appellate court case. Quote, constitutional protection for defendant's speech hinges on state of mind issues, particularly whether he intended his communications as threats and whether his victims were reasonable in perceiving them as threats. Deferential review of such questions creates an unacceptable risk of underprotecting speech. It is our constitutional duty, then, to, quote, make an independent examination of the whole record so as to assure ourselves that the conviction does not constitute a forbidden intrusion on the field of free expression. That's unquote. And, it's weird. But she goes on to say, harassment is defined as conduct directed towards a victim that includes, but is not limited to, repeating or continuing impermissible contact that would cause a reasonable person to suffer emotional distress and that actually causes the victim to suffer emotional distress. Impermissible contact includes, but is not limited to, 1, following or pursuing the victim. 2, communicating with the victim. 3, posting on social media if the post, A, is directed to the victim, or B, refers to the victim directly or indirectly. So that's so that's what the Indiana state government is saying is harassment, or sorry, is impermissible conduct. So if you repeatedly post content that refers to somebody, that under Indiana law could potentially constitute harassment, which is insane, right? So even if Karanovich, this is continuing on, even if Karanovich had been the target of, quote, threats, unquote, from any of the unknown callers, any reasonable person would understand that anonymous callers would likely have no access to do her any harm. She avoided conversation with Craig, even at City Hall during 2023. Her, quote, fear, unquote, was the result of the combination of her always present unease, her apparent general wariness of people who have tattoos, which I thought was an interesting inclusion in my appellate brief because I don't have any tattoos. But perhaps that, I don't know, perhaps that had something to do with it. And anyone with a camera filming in City Hall. Karanovich exhibited no fear when she was in the hall brandishing her phone and smiling. She exhibited no fear when she politely asked Craig if he'd like her to give the mayor a message. She testified that when she saw Craig at the town council meeting, her stomach turned, but only mentioned during a pre-trial deposition that she felt, quote, uneasy, unquote, just an uneasy person. Craig cannot be held responsible, let alone criminally liable, for Karanovich's testimony that she was in fear and such an unreasonable response. The conclusion is because the state failed to prove each element of the harassment, of either harassment or stalking, as charged, this court should reverse the convictions, vacate the sentences imposed, and grant all other relief that justice requires. So that is that's what my attorney filed, and of course, like I said, that was a very brief and in a nutshell, version of that. So now what I'm going to do, if I remember how to use StreamYard correctly, is I'm going to share my screen with you, and I'm going to show you the state's response. Let me see if I'm sharing that. So I'm going to get that to where it's full screen here. All right, and I'm going to zoom in a little bit for you guys. How's that looking? All right, that's looking good. So this is the state's response. This is the brief of the appellees. This is the state of Indiana responding to my brief, to my attorney's brief there. So you always got all these table of authorities and all of this, and they don't mention them until later in the case. So they go statement of the issue. Whether sufficient evidence proved Craig Hendry, defendant, committed level 6 felony stalking and 2 counts of class B misdemeanor, aiding, inducing, or causing harassment. Statement of the case. On October 6, 2023, the state charged the defendant with level 6 stalking, victim MF. I don't know who that is. Class B misdemeanor harassment, victim Patty Karanovich. On October 11th, 2023, the state dismissed one count of level 6 felony stalking, victim MF, and the count of Class B misdemeanor harassment, victim Patty Karanovich. On February 21st, 2024, the state charged the defendant with 2 counts of Class B misdemeanor harassment. One count pertained to the defendant's conduct between April 22nd, 2022 and June 1st, 2022. The other count encompassed conduct between September 13th, 2023 and November 7th, 2023. On November 14th, 2024, the state moved to amend the count identifying conduct between April 22nd, 2022 and June 1st, 2022 to encompass now April 22nd, 2022 to November 3rd, 2024. And keep in mind, my trial occurred November 18th to November 21st. November 19th to November 21st. So they amended the charging information essentially 2 weeks before my trial. On November 15th, the trial court granted the motion over the defendant's objection. A jury trial was held November 19th to 21st, and defendant was found guilty of level 6 felony stalking and both counts of Class B misdemeanor aiding, inducing, or causing harassment. On December 17th, 2024, the trial court sentenced the defendant to 548 days in jail for level 6 felony stalking and 180 days in jail for one count of Class B misdemeanor harassment, and ordered both counts to run concurrently. The trial court vacated the second count of Class B misdemeanor harassment due to double jeopardy concerns. The defendant filed his notice of appeal on January 3rd, 2025. All right. So this is statement of the facts, and I'm going to give you guys a fair warning. If you're going to stick with me, that goes from page 6 to, let's see. Oh, goodness. That's a long, long bit. So, we'll read a couple pages of their statement of the facts because I'm sure it's just going to be one by one going through. I went to City Hall. I went to the back. So we'll read a little bit of it just so you guys get the gist of what they're saying. And then we're going to come back to this. It's going to be argument. And that's where the juice is going to be. That's what we want to look at. So I'll go ahead and come up here. Oh, hold on. They have summary of argument. Let's see. Yeah, sorry if this is incredibly boring watching me scroll. So I'm just going to jump in somewhere. So this is like middle of the statement of the facts. There's a little bit before it. There's a little bit after it. So on September 13th, 2023, defendant entered the lobby of City Hall and walked down the hall towards the mayor's office. On his way, the defendant opened a door marked authorized personnel only and began filming. He then entered past a sign that said employees only beyond this point and knocked on the door to the mayor's office. The mayor's door read Jack Guilfoyle, Mayor, and had a glass window with blinds pulled shut. Defendant knocked repeatedly on the door, called out to Patty, and accused her and the mayor of having a, quote, fling. Officer Finley, I believe it is, responded to City Hall based on a report by the water department that the defendant was in front of the mayor's office harassing the employees. Specifically, Officer Finley was told that defendant was in the building and trying to get a hold of Patty, and that Patty was scared. When Officer Finley arrived, defendant was in the hall speaking with the clerk treasurer. Officer Finley closed the door marked employees only twice to defendant. Defendant said he was there to inspect the records. Officer Finley eventually left defendant to, quote, finish what he was trying to do, but directed him not to harass anybody or anyone. The defendant posted the video of his interactions from his September 13th, 2023 visit to City Hall on 2 separate YouTube channels. As of September 14th, 2023, one video had 27,544 views, had been shared 1,800 times, and defendant had 54,600 subscribers. The defendant's thumbnail for the video read, and this is a long thumbnail. I'm not sure that I made the thumbnail like this. In this video, I showed up to Clinton City Hall in an attempt to have some of my questions answered. Instead, I run into some very loud and dangerous creatures. Enjoy. To complain and ask Patty why Patty isn't working in the water office, the Clinton mayor's office is 765-832-7577. Right. And, I did actually say, I noticed this earlier. I said I didn't encourage anybody to call. In this, it does appear that I say to complain and ask why. I am saying, like, if you want to ask why, and somebody could interpret that as encouraging her to call. The instance that I was referring to is they said that a whole bunch of like 600 or 700 phone calls came in, and that happened immediately after another video, in which that video I did not encourage anybody to call in the thumbnail. This video, actually, no threats were precipitated by this video. As far as was told in trial, it was all from the first interaction, which was a pretty horrendous interaction. I've removed it from YouTube until the appeal is up, and and then after the appeal is over, we're gonna see about getting it back on there. We're gonna talk to the attorneys about it, and even so, Lackluster has the video and a lot more on his channel. I think it's called Exactly as They're Told, Felony Charges, or something like that. It's like the title of it. But if you're interested in seeing the video that they said precipitated these threats, and there were threats, like, I can't lie, there were a lot of people that called after that first video that I posted in like April of 2022, and they were saying really horrendous things like, I want to kill you and all this. And I do not condone that. I think that that's actually really, really horrendous to say about somebody. Now, don't get me wrong, that doesn't stop the government from saying it or doing it, but I don't condone it myself. But I certainly never called anybody and said that. That was other people that did that. And those people's names were never found out. They were never looked into. Of course, I'm not exactly saying that somebody should, but I'm saying, how did I get held accountable for their threats? That was something that, and I don't even know if like 9 months in jail is accountability for telling somebody that you're going to do something to them, but I certainly didn't do that. I was held accountable for 9 months in a county jail, being basically mentally tortured by cops because other people called, and the government cannot have people calling them. And so in order to send a message to not to the people who called, but me, the guy who makes the videos, like, hey, you're not going to make these videos. You're not going to show people the bad things that we're doing because they're getting mad. So we're going to throw you in jail. And that's what they did. And of course, that's what they're still trying to do in 2 other counties and 3 other cases. So we are going to move on. So we're going to move on to the argument, right? So this says, this is the state's argument, remember, sufficient evidence supports defendant's convictions. There was sufficient evidence to sustain the defendant's convictions for stalking and aiding, inducing, or causing harassment. And defendant's conduct is not constitutionally protected speech. In examining the sufficiency of the evidence, this court will not reweigh evidence or reevaluate the credibility of witnesses. This court considers only the evidence most favorable to the judgment altogether, with all the reasonable inferences that may be drawn from the evidence. If the evidence and those inferences constitute substantial evidence to support this judgment, this court will affirm, because the fact finder may apply its common sense to the evidence, and because the evidence need not overcome every reasonable hypothesis of innocence. This court must affirm a conviction, quote, if the probative evidence and reasonable inferences drawn from that evidence could have allowed a reasonable trier of fact to find the defendant guilty beyond a reasonable doubt, unquote. This is subsection A of their argument. Sufficient evidence supports defendant's conviction for Class B misdemeanor harassment. The state sufficiently proved that the defendant aided, induced, or caused the harassment of the employees of the city of Clinton. To prove harassment beyond a reasonable doubt, the state was required to provide evidence that the defendant aided, induced, or caused his YouTube followers to place telephone calls to Clinton city employees, and that calls were made with the intent to harass, annoy, or alarm these employees and had no intent of legitimate communication. Right. So I'm going to reread that just for everybody so that they can really listen to this. This is what they're saying. To prove harassment beyond a reasonable doubt, the state was required to provide evidence that the defendant aided, induced, or caused his YouTube followers to place telephone calls to Clinton city employees, that the calls were made with the intent to harass, annoy, or alarm those employees, and had no intent of legitimate communication. So I'm going to go over that. One, I cannot control what the intent of those phone calls was. When they made them, I cannot control anybody else's intent, right? So if somebody had ill intent making a phone call, sorry, I didn't make the phone call. I can't control what other people do, right? Everybody has their own control over their own voice, if you can speak. So, I can't control that. So, but then they say that, that I had to aid, induce, or cause my YouTube followers to place telephone calls. So obviously I couldn't have aided anybody in doing that. At least not YouTube followers. They said that there were 40 different states. They tracked phone calls from 40 different states. So I obviously couldn't have coordinated an effort like that as far as aiding somebody. Of course, I don't know what that would be. Maybe buying somebody a phone, or paying for somebody's phone plan, or I don't know, doing something like that. But I didn't do that. They didn't accuse me of that. So they accused me of inducing or causing it. So causing is so broad. It's am I in charge of what I cause people to do? Or do I have to be careful with what I say because it might cause somebody to get mad and do something? I don't know how I can control that. I make people mad no matter what I do, right? I could sit and say something that pleases my YouTube followers, and I get death threats in my emails. Right? And this is no joke. I don't ever make this public because I don't care to give people attention. And I will not give any individual attention. But I get death threats in my email talking about, all you do is hate police. If you come to my town, you're a dead man and all this. And, I don't know, there's nothing that I could say that's not going to set somebody off, that's not going to cause some anger. So, and inducing, I don't know exactly how I would induce. I think inducing, I think I'd have to say, hey, do this, I'll pay you for it, or do this, inducing means that I would have had to, convince them to do it, or, I don't know, cause them to do it. Yeah, inducing and cause, it just seems like the same language to me. So, but I can control that, right? If I say something, somebody could get mad and do something crazy, but it's not my fault. I didn't cause them to do that. Maybe I caused them to be angry, but that doesn't mean that every action that they take afterwards is also my fault, But either way, I just thought that was an interesting thing. But of course, we're leaving what it means to have free speech when we're talking when we're talking about all this stuff. When we see what the state is trying to say here, and of course the repercussions of these these actions that the state's taking. So I'm going to go on. It goes, the substance of defendant's videos makes clear that his purpose was to produce sensational videos that sought to instigate action from his viewers. This is demonstrated by defendant repeatedly entering unauthorized areas within City Hall, trying to goad Chief McLaren into a fight when he is asked to leave, calling the government workers he meets names like clown and pig, and suggesting that the government workers he encountered during these interactions were failing to do their job. Defendant's goal of creating videos intended to generate a public response and gain a large following was also shown Oh, sorry. So they're saying my goal of this was also shown by the fact that he sought to make a profit from them, either by requesting that viewers pay cash, which I never request that anybody pay cash. I always say, if you support my mission, if you see what I'm doing, you see I make a lot of sacrifices to raise the alarm about this terrible government that's doing terrible things to us. So of course, if you're inclined to support that mission, please give me some money. It always helps out. I got my Cash App and my PayPal in the description for a reason. But of course, I don't ever request that you guys do it. I understand everybody's going through tough times in America right now. Even if you're wealthy, you most likely having to cut back on something. So, but either way, let's go on. I'm just gonna set that straight, though. I did not request anybody do that. So, in addition to receiving an automatic profit based on the number of views, subscribers, and ads within the videos, the ultimate result of defendants' efforts was that each video received hundreds of thousands of views, and of those viewers, many were encouraged to take action by calling City Hall to complain and ask why Patty was not working in the water office. Right. And of course, if they're saying that I encourage somebody to call, complain, and ask why Patty was not working in the water office, why does that matter? What if people ask why a government employee isn't working in the office that they're getting their paychecks from? Right, that was the issue at the time. It may not be a big deal, but of course it's all right to ask a question, right? So that's what they're saying constitutes me encouraging people to call and make threats. It's ridiculous, and I'm going to say it right now. The court has not ruled on this yet, but I am not going to put it past the Indiana courts to say, yes, the defendant saying, if you'd like to call City Hall and complain and ask why Patty's not working in the water office, here's the number. And they're going to say that was encouraging intimidation and harassment. That's ridiculous, right? The idea that I could have known that would have precipitated threats in their direction. This resulted in the mayor's office receiving hundreds of phone calls of an offensive and threatening nature. That the phone calls were a direct result of the defendant's video posts is shown by the number of calls to the mayor's office by the fact that the number of calls to the mayor's office increased exponentially the hours, days, and weeks after. Defendant posted and reposted his videos. At least one call directly referenced the defendant's videos, while others mentioned YouTube and topics mentioned by defendant in his videos. And this is an interesting point. I don't know why I never brought it up, but that video was shared by other people, by other YouTubers. And, who knows, right? Maybe who knows how they got that number, right? So maybe they got it off my video. Maybe they got it off somebody else's video. Maybe they watched the video on somebody else's channel and just looked up Clinton, Indiana, went to the City Hall page and got it from the public website that the city runs. I don't know, right? Who does know? But they never proved it. They never proved it was my video, who could, right? So it goes, the intent of the hundreds of calls was shown by the substance of the voicemails that were left, in which threats and offensive comments were made towards the mayor, chief of police McLaren, Patty, and other individuals appearing in defendants' videos, and which ranged from threatening to torture Patty to wishing Marcy would see her family bad word in the street. And like I say, I do not encourage any of that, right? I don't encourage making threats to people over the phone. It's not productive. I don't think it should be illegal. I don't do it, but I don't condone it. I'm not going to say that, that's something good that you should do. So it goes on to say, indeed, out of roughly 400 voicemails, Patty found only 3 to be inquiries for assistance from City Hall. As a result of defendant's conduct and the calls stemming from the videos he posted, both Patty and Marcy were emotionally distraught. Specifically, Patty stopped walking to work, began staying inside of her house, began therapy, sought medical treatment, and was put on medication for depression and anxiety. She felt terrorized and threatened by defendant and everyone he entices. Additionally, Marcy sought medical treatment and began taking anxiety medication. Given the hundreds of thousands of views each of defendant's videos received, that he included the phone number of the office that he received the calls, or sorry, that he included the office of the number that received the calls, and that did so because people previously asked him for the information so they could call. It was reasonable for a jury to infer that not only did defendant know and intend that his videos would be distributed and received amongst a wide audience, and of course that's a crime. You know, if you make a video on social media and you intend for that video to be distributed and received amongst a wide audience, that is clearly, you know, the government can't allow that. And I'm a perfect example. So, you know, just the intent to do that alone that's a part of the crime, right? That is a necessary, a necessary element to the crime here, of course. So then they go, but that many of those viewers would use the phone number provided to contact the office to complain about the issues defendant himself complains about in the videos. Thus, the state proved the defendant aided, induced, or caused the harassment of the employees of the city of Clinton. And of course, then they go on to say that when harassment, and of course, that's what they're saying, this is when harassment causes somebody to be intimidated, threatened, or, you know, terrorized, that then constitutes stalking. So then they go on to say that because I complained in the video, because I included the phone number, and because I posted it for a wide range of viewers, that I harassed them. So then they got scared. So now it's stalking as well, which is incredible. And I'm not. I wish I was exaggerating. I should post these online for everybody to dissect. I think I will do that. I think I'll probably post links to them so that everybody can see them on my YouTube, is it community page? So, but now I want to show everybody our response, which is short and sweet, and I intend to keep the rest of it short and sweet. I think I said I didn't want to go for an hour, and yeah, I'm already pushing 40 minutes. So that was I don't know. Well, we'll see if we can keep it under an hour. But all right. So I am now going to show you my brief that my appellant attorney generated and filed on my behalf. All right. So this is the reply brief of the appellant. And like I say, it's pretty short. It's only 8 pages. So, and the 8th page is basically nothing. So this is the summary of the argument. Patty Karanovich was not targeted by Henry, and his only contacts with her were all in pursuit of his right to redress grievances with the Clinton city government under the First Amendment to the U.S. Constitution and Article 1, Section 9 of the Indiana Constitution. To prove the charge of harassment, the state relied on the conduct of other people, unknown to Henry. The conduct of these persons was even unknown to Henry until the charges had been filed, and his attorney received the discovery materials. The state's reliance on Stone v. State undercuts the state's argument. The language of the harassment statute is readily justified without reference to the content of the regulated speech. The state's purpose for enacting the harassment statute was to prevent a person from using a telephone with the intent to harass, annoy, or alarm others, and with no intent of a legitimate communication. The statute is expressly framed around the speaker's intent, not around the content of his speech. Accordingly, the statute on its face is content neutral. The state's argument is grounded in the assumption that Appellant Henry made the phone calls that were received at Clinton City Hall. He did not. Failing that argument, the state asserts that Henry incited the other callers. There was no evidence of any connection between Henry and the numerous callers who left messages on the City Hall phone. The uncontested evidence at trial was that Hendry was completely unaware that any calls had been made following the airing of his video on the internet. The state argues that Appellant Hendry pursued and agitated Karanovich over the course of several months, despite knowing his contact was unwelcome. Indiana cases that address the sufficiency of evidence of stalking have a factor in common that is not presented in this case. Quote, sufficient evidence existed that defendant's conduct constituted repeating or continuing impermissible contact towards the victim, as required to support stalking conviction, unquote. This court held that, quote, telephone messages without more may amount to impermissible contact, sufficient to support a stalking conviction, unquote, where a business owner was targeted by the accused, followed to various locations, and, quote, rushed her, unquote, coming out of the post office. The evidence was sufficient to support stalking. Following the victim in an automobile for hours constituted, quote, continuing harassment, unquote, in violation of the stalking statute, criminalizing, quote, repeated or continuing harassment of another person, unquote, which expressly included following or pursuing the victim, even though defendant's conduct was not repeated. In all of these cases, the named victim was a direct target of the accused. In this case, Patty was never targeted by Hendry. The state argues that because Patty hung up after a conversation wherein Hendry asked for the video she had laughingly recorded on her cell phone, that, quote, contact, unquote, was impermissible. Likewise, Hendry's statement that he intended to file suit if he was denied review of the records to which he was legally entitled can hardly be found sufficient to support a finding that Hendry was stalking Patty. On other occasions, Hendry's contact with Patty were tangential to his stated mission. In reference to the phone calls to City Hall, the state argues that, quote, the speech defendant incited was contrary to the recognized substantial public interest in protecting persons from telephone harassment because it was threatening and incited fear in those it was directed towards. Under the state's theory, the government must show that Hendry actually made the calls, which he did not, that Hendry intended the callers to behave the way they did, or that Hendry somehow incited these callers. Incite is defined as to encourage someone to do or feel something unpleasant or violent. Right? Hendry did not harass or stalk Patty Karanovich. The state asserts that defendant knowingly harassed Patty by engaging in repeating or continuing acts of impermissible contact, which both objectively and subjectively caused fright. According to the state, any contact Hendry had with Patty were impermissible contacts. This argument attributes an intent on Hendry's part that was never proven beyond a reasonable doubt. The state improperly characterizes the result of Hendry's exercise of his free speech and expression, i.e. the numerous phone calls to City Hall, as proof that Hendry intentionally contacted Patty with the goal of putting her in fear. The state argues that defendant's conduct is not protected by the First Amendment because his conviction is based not on the content of his videos, but because he made the videos and encouraged the public to act on what they saw, thereby inciting the illegitimate and threatening phone calls to Clinton City employees. The state does not address Hendry's argument that this is a free speech case. It is this very argument that undercuts the state's position. Hendry's conduct is the very first thing that the First Amendment and Article 1, Section 9 protect. Hendry admittedly became exasperated when he was stonewalled in his attempt to collect information and examine public records. There was no direct threat to Patty. Patty was apparently the, quote, front line, unquote, to the mayor's office as a result of the mayor's refusal to speak to Hendry or to provide the information he sought. Patty was the only one who Hendry could speak to, and that is true. I mean, the mayor's never in his office. The mayor is actually dead now. Jack Guilfoyle Jr. died rest in peace to him. He was one of the main engines behind my conviction and me serving time in jail. He actually went to my sentencing hearing and stared me down, like gave me the stink eye the whole time. Because I turned around and I winked at him, but he was instrumental in getting me put in jail. But we're bigger than them. I don't wish ill upon anybody. I just wish that people would stop violating other people because they call themselves government, right? And so that's basically the gist of it. But yeah, it is. So I'm seeing comments now. Uh I can answer some questions if anybody's got any questions for me. I can answer some questions, but I don't know if anybody's got questions. With that being said, everybody, I'm pretty much I just wanted to get this out there and get everybody the information on what the state is trying to convince the state court to do. They'll most likely do it, right? They'll most likely uphold my conviction. If they don't, great, right? But they most likely will. So I'm gonna scroll through here and see if we got anything. Yeah, I don't think anybody's got any questions. So with that being said, everybody, thanks for being in the stream. Thanks for joining us. This is one of the most important issues. As much as the social media platforms will, shadow ban channels like this, channels like, like everybody who does this stuff, Johnny 50, AFA, James Freeman, all of these guys, they're all getting shadow banned because Americans care about this stuff and they don't want people to see it, because the more Americans that get involved, the more Americans that get aware, the more people living in this country that understands the threat, the daily threat that's posed to them by their government. Uh, those are the people we're trying to reach. Those are the people they don't want us to reach. So thank you all for being here. Share the video, like it, comment your thoughts and opinions in the comment section. I've seen you all on the live stream in the chat. With that being said, everybody, take care. Thanks for being here. We'll see you in the next video. Hopefully it won't be another 48 days or 50 days. So we'll see how it goes. This thing will keep you updated. The next few videos, I think I might give everybody kind of an update on the Sullivan case. But we'll see. We'll see how it goes, everybody. We'll see you in the next one. Take care.